Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everyone, welcome into an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph Jordan, the founder over at Jordan UCMJ Law Group. I'm your host, Mike Leon. You know, Joseph here is a former Army JAG, worldwide court-martial defense attorney. He's tried more than 240 court-martials to verdicts, and he's handled hundreds of military cases all across the U.S., Europe, the Pacific, and in the Middle East. Today's episode, we're going to be talking about direct examinations. Joseph's going to explain how stories actually enter the courtroom through witnesses and how clarity, rhythm, and credibility, they matter a lot more than the theatrics. Joseph, it's good to see you as always. I'm in the theatrics business, right? Obviously, as a host. But for you, when you're first preparing for direct examination, what's kind of the first thing you want to be clear about before a witness even takes the stand?
First of all, Mike, thanks for having me. What's the first thing I care about? Is it the truth? I can't put a witness on the stand that's going to lie. First of all, it's unethical. Second of all, it's illegal. You don't want to put a witness on the stand that you know is going to perjure themselves. So the first and foremost, the thing that I'm most concerned with is, are they telling the truth? And that comes with proper investigation of the case, not just interviewing that witness, but interviewing other witnesses, sitting down and closely understanding what they're saying and picking apart everything that they've said to ensure that what they're saying on the stand is unassailable.
You know, direct examination, I always think of the movies. I told you this about like A Few Good Men. They're prepping that witness for direct examination because that's where the jurors are really going to get connected with the facts, right? So how do you, in that vein, how do you think about the role a witness is going to play in helping the case, helping the panel, I should say, understand what matters in the case?
As I've stated in previous episodes, does it further the narrative? How does what they have to say actually further the narrative and get you where you want to go? That's really and truly the important thing here. If it doesn't further the narrative, then what are they doing taking the stand? You have to understand what is the objective to your case. It's to get a full acquittal. And the strategy that gets you there, what is the touch point? What is the most important thing to that strategy to get you there? And if the witness doesn't help you get you there, they don't take the stand. It may be that the witness has one or two facts that you need, just one or two facts, and you keep that scope very, very narrow, and you're very assured that there's nothing that can come out of that witness's mouth that's going to hurt other parts of your case. Then put that witness up for those one or two questions and get them off. Right? That's what I focus on.
You know, I want to stay with that for a second because I'm sure you've encountered this in your history, right? Where some witnesses are better than others, right? Some are good storytellers, some are just not. I mean, I deal with that all the time, right? With guests, right? You got to get a little bit more out of this one versus not you, Joseph, in particular. So how do you kind of adjust your approach in that regard so the testimony is real clear, it's believable, it doesn't feel forced?
As I think about that question, I think about the panel and how educated they are. They're very experienced in life. They're very experienced with service members. And if you're putting fellow service members on the panel, there's going to be some expectations. And so if you've been in the military long enough, you learn how to read people, especially if you're a leader. And most panel members have held a leadership role or are in a leadership role. And part of their job is reading people and understanding how to talk to their people. And so hopefully you have individuals who are, what is the term, emotionally intelligent, and so that they're able to see what you see. I never want to force an individual to be something they're not. If they're taking the stand, you want them to be who they are. Message how they are, because oftentimes that will also help move the narrative along. It'll help give needed context and needed background on how a certain thing may have occurred, right? How that person views information, how that person communicates. So if they're a very stoic person and they communicate in a very stoic way, or they're a very matter of fact person and they communicate in a very matter of fact way, or they're a very intelligent person and they use big words. I'm not going to dumb it down. Um, and I'm not going to intelligent it up, if that's a word or a phrase. So be who you are, because that gives raw reality to the situation, and members can start to see how uh, certain things have come together to create the problem that they have to solve that's in front of them.
Speaking of be who you are, we've talked about this in previous episodes about body language, pacing, especially during opening arguments, voir dire. Now let's get into the direct examination part of this. Like what are you paying attention to about you yourself in the room that lets you know what, I need to slow down here. I need to move on from this line of questioning. What is it?
First and foremost, you want to master your case file so that you understand what your objective is, number one. And sometimes you can get so into the weeds in your preparation that you realize if you're getting to a point in the questioning with a witness on the stand, there are times where you might get bogged down in a situation and they're not saying exactly what you thought they were going to say. They're not exactly saying what, when you interviewed them or you prepared them to testify, they're not saying exactly what was prepared. And so I've had situations where individuals have lied on the stand, and it wasn't an actual lie. It was they misspoke, and so you got to correct it, right? So you want to pay attention to what they're saying, pay attention to what you're saying to get them to say what it is they're supposed to say. But you also want to make sure that you don't get bogged down in a situation that's putting the members to sleep, right?
Right.
So you pay attention to the answers if they look confused or if they start going off on a tangent. Oftentimes you got to control that. Usually you keep that from happening because you've prepped. And, you know, having done this for as long as I've done it, I typically don't put a witness on the stand that's going to create a problem like that to where I have to correct on the fly. It happens not very often. It doesn't happen that often anymore, but nor did it really happen before, because you really have to think about these things. If you're wanting to put on a good case, you really have to think about the messaging. Every witness matters, and these members know that. So they're going to wonder, why did this person take the stand if they didn't offer me any good information, or if they're just spinning off into space with speculation? So those are the things you look at and focus on.
You know, a second ago you were mentioning about whether or not to put a witness on the stand and they can get like one or two facts out of that witness. I'm sure you've seen other situations where maybe there's too much detail that muddies the story a little bit. So in that instance, how do you decide which facts really matter and which ones can kind of stay in the background?
So it depends on your objective, right? Every witness to a case is a piece of the puzzle. Are you going to paint the picture that you want to paint with the facts that are coming from this witness or not? That's the analysis. And if they are not giving you the pieces of the puzzle to create the picture you want to create for the panel, then you either don't call them or you don't ask those questions. Some witnesses, they give you one or two minute details, and that's all the details that you need. Uh, Keep it short, simple, and to the point. But if there's someone that you know is just going to run off the rails, and you can get those facts from some other way through cross-examination or through another witness or whatever, then that's what you do. So it's careful preparation and making sure that they are giving you the exact puzzle piece you need, or the exact Lego piece you need to create whatever it is that you're trying to create for the panel.
You know, in a previous episode, we talked about witness credibility and how them sharing one moment kind of didn't jive with the common sense aspect of this. What are things that you've seen that kind of tend to shape how a panel reacts to a witness during direct examination?
It's how they answer the questions and whether or not the questions themselves and the answers to those questions themselves ring true. Really, that gets tested on cross examination. So oftentimes you don't know if you prepped a witness and they say what you've prepped them to say, and you've red teamed it, and you're confident that what they're going to say is the truth. And then you get surprised on cross examination. Now you got to think about, well, what am I going to do on redirect to clean up this mess? And sometimes it's a situation where it's a subtle confusing point, right? So they've been subtly confused about about a particular fact, and so now you got to turn around and remind them. And usually you need to remind them with something that is clear, something that is tangible, so that the jury continues to know you, like you, and trust you as the advocate because you're the one that put this witness on the stand in the first place.
You know, a moment ago, you also mentioned mastering the case file, right? Preparation's critical, but these witnesses, they're still human, right? So how do you personally, how are you accounting for their nerves, their stress, maybe the unexpected answers that they could give once the testimony begins?
So that comes with preparation, sitting down and talking them through what to expect, right? Much like a coach does with their players. Hey, we're going to get in some dicey situations. Here's how you need to read that. Oftentimes, when I'm talking to a witness and prepping them for testimony, it's tell the truth, right? The truth is cathartic anyway, right? Just tell the truth, whatever the truth is. Tell the truth. Stay rooted in the truth. And if they come at you sideways, as they like to say, if they come at you from an angle that you didn't expect in cross examination, continue to tell the truth, because I'm going to come back up and I'm going to bring it back to the point of your testimony, plain and simple.
Can you share, staying with that, can you share kind of a case where the direct examination unfolded a little bit different than expected? Maybe it still ended up strengthening the defense for you guys. Like, what would you take away from that experience?
So I don't really have an experience like that, and I'll tell you why. When you're preparing a case, and first and foremost, let me just kind of roll back. In our training from law school and any subsequent advocacy training that we have had, it is taught to us that you should not put on a case. You should never put on a case as a defense counsel. That is kind of the rule of thumb. You should win your case through cross-examination. There's books written about it. There's classes on it. That is the rule of thumb. Never put on a case. The military is different, though, because everything in the military is built upon integrity. Can I trust you? And so you have to be able to trust the man and the woman next to you in the foxhole. So they should be able to take the stand and tell the truth, right? Now, juries are instructed at the beginning of trial and at the end of trial not to hold it against the accused if they don't testify. But that's the number one bias we have to fight against if your client does not testify, number one. But getting away from clients and looking at witnesses themselves, why am I putting the witness on the stand? What is the point? And if I'm not moving the needle, if I'm not challenging a cross-examination point, because oftentimes that's what I'm doing, right? If I've cross-examined a witness and if I didn't get them to properly recollect what they'd said in the past that was contradictory to the statement they said on the stand, then I have to impeach them. And if I can't impeach them with what's known as extrinsic evidence, or evidence that's outside of what they've been, questioned on. Then I, like another statement, those sorts of things. Then I got to call a witness to complete the impeachment, right? So it's got to be, I have to think very carefully on the types of witnesses I call and why am I calling them? Are they furthering the narrative? Are they bulletproof? How can they get through my withering cross-examination? Because if they can't, they don't take the stand. The one example that I can give you was a child sex assault case I did at 1st Cavalry Division at Fort Hood. This was back when the courtroom for 1st Cav was actually in the 1st Cav headquarters. It was on the 3rd floor of their headquarters building. And the case was, the case was centered around the alleged victim. It was an older case, and it had taken them a while to get to trial. We had significant motions practice on it. And we get into the courtroom to try the case, and I cross-examined the alleged victim for about 4 hours or so. We had numerous amount of video statements that she had given where she had made contradictory statements to what she testified to in trial. And I was able to impeach her on all of those things in front of the panel by putting the discs in, playing it. Isn't it true you said this? Isn't it true you said that? And this contradicts what you said in the courtroom, things of that nature. We had a case dependent upon our client testifying and saying what he had to say. He was a field grade officer. And also, we had about 11 witnesses lined up, ready to testify, thoroughly vetted, ready to go. After my withering cross-examination of the alleged victim, the government rested. They rested. So did I. I did not put on a case. Full acquittal. We selected the jury. They called their witness. I cross-examined the witness. We got to closing arguments, and we got a verdict, all in the same day. And that is unheard of in a child sex assault case. That hardly ever happens.
It's a great story. I did want to close on this because we've been talking about direct examination. So for the people that are listening to this, what would you want them to understand about why direct examination is less about controlling the witness and more about letting the truth, as you mentioned before, come through clearly?
I think you hit the nail on the head again. It's making the panel feel comfortable with the facts of the case. They have to feel comfortable with what they're going to deliberate over, right? So only give them information that is bulletproof, information that is unassailable. So if someone's taken the stand, you don't shape their narrative. Their narrative is what it is. It's static. So if what they have to say isn't helpful to your case, don't put them on the stand. If what they have to say is helpful to their case and is unassailable, you put them on the stand. And that helps the fact finder, the military panel, decide what really and truly happened in a certain scenario.
Right. We all have a job to do in that courtroom. Joseph, I can't thank you enough for the time, the insights, explaining all this to the audience. I appreciate it as always.
Thank you, Mike. Happy to do so.
And thank you to everyone out there for listening to this episode of Courtroom Quarterback with attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, do me a favor right now, visit jordanucmjlaw.com. Don't forget to like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. As always, I am Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.